Texas gives the landlord the choice of cure or no cure in the 3-day notice for non-payment. After sending a notice, tenant deposits rent into the landlord's bank account. Is the 3-day notice still valid? Do you need to refund or proceed? This is based on that operative word choice. Yes, you can send a notice to pay or quit, but that's not required. Your notice to vacate for non-payment could say unequivocally, get out. That's what my notice says, in effect. I don't give an opportunity to cure in my notice because the default provision in your lease says that non-payment of rent, if, again, it occurs beyond the date that it's due, and most leases require that rent is due on or before the first day of each month. If non-payment of rent occurs, you can demand possession with a 3-day notice to vacate without giving the opportunity to cure. If you sent your notice and it says cure or to pay or quit, or if your lease gives an opportunity to cure, or if your notice itself says you can pay and you can stay, then naturally, if they pay, they can stay. But without that, let's say your notice to vacate just says, get out in 3 days, your lease is hereby terminated due to your non-payment. And let's say we're not even dealing with a few days. Let's say you sent this on day 7, and on day 9, they drop a payment into your bank account. You've got a couple of options. And number one is you could reject that payment and send it back to them. I'm proceeding with my eviction. That's not what I tend to recommend to landlords. Instead, I tend to recommend to landlords proceed with the eviction filing. Now, by the time you can file for eviction, you could state the following in your eviction petition. Rent is X. It was unpaid at the time I filed my petition, but as of right now, $0 are due in rent. And then proceed to the trial. And at trial, you can tell the court, I sent my demand letter, I sent my notice to vacate prior to receiving any money. Money was later deposited into my account. If the subsequent month, though, depending on when you go to trial, there could be another month that was, again, also deposited in your account, so that you have a $0 judgment for possession. But such a thing is possible. And you tell the court very plainly, my damages are 0, but I still want possession because the tenant violated the lease, paid late, and late payment is also a default. And so the judge may go one of two ways. May say, well, if you intend to collect a judgment, you're going to have to refund the money. There are some judges who would say that that's necessary. I don't believe that's what the code says. I don't believe that's what's required. But if you desire possession more than you desire rent, show up to your eviction trial, prepare to do that very thing. In fact, if the judge starts weighing this as a possibility, let the judge know unequivocally, I am prepared to refund any amounts that were paid to me in rent because I want possession more than I want this rent. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Additionally, the judge may say, you can keep the money, but I'm going to give you a $0 judgment. The one thing you want to make sure you do for sure in your eviction trial is make sure that the court establishes for purposes of a potential appeal that rent should be paid into the court's registry during the pendency of an appeal. And the reason this is important is because sometimes a tenant will lose in the justice court and appeal, and if there's a $0 award for rent, the clerks sometimes assess a $0 amount due in future rent for a party who appeals an eviction. So you want to establish that rent for purposes of the appeal is established at the stated rental value, and that if the defendant intends to appeal, that they are required to pay rent into the court's registry month to month as it comes due at the stated rental amount. Do you proceed? Always proceed. Leave it up to the judge. And here's what tends to happen, is if you proceed and there is a subsequent month owed, if a tenant knows they're being evicted anyway, they usually don't make that second rent payment. So you show up to trial and you're able to testify to an amount of unpaid rent. And so that usually happens. But a tenant who goes and makes the payment and fights, that's the situation where you have to decide, look, I'm being paid, okay, I'll just drop the eviction. Or I'm being paid, but I want possession back so badly that I will let the judge know I am willing to issue a refund so long as the court marks in the file that rent is established at X, your rent amount, in the event that an appeal is filed. So it's a little bit complicated, but yes, you can still get an eviction judgment, particularly if you are more interested in possession than you are in that particular rent.